Hi, Tessa. How are you doing?
I'm good, thanks. How are you?
Excellent, excellent. Cool. Well, thanks so much for your time. I will walk you through a few questions now.
Cool.
Awesome, awesome. So maybe to start with, maybe could you walk me through a typical process when you sell or acquire a brand?
Absolutely. So step number one, where you really want to get a lawyer involved, I'd say, is the LOI, the letter of intent, which is your heads of terms at the beginning of the transaction. That sets out all the key terms of the deal. I find probably that only about 50% of clients come to me with their LOI. About another 50% have actually signed it before they come to me. I would really encourage clients to come to me before the LOI is signed, because it's so common that I then find mistakes in the LOI. They've missed something out. The parties have misunderstood something. And those are all issues that I could have cleared up beforehand if they'd spoken to me. So step number one, LOI, speak to a lawyer, definitely. Once you've got your LOI in place, the next big step is the due diligence. So that's when the seller will answer a whole load of questions, probably some of them through meetings, some of them through a Q&A spreadsheet, and all of that will be backed up by documents that they put into a data room. I find a bit of a mix here as well. So sometimes on DD, if I'm acting for an aggregator, I'll probably only just do the legal due diligence, look at the legal documents for them. If I'm acting for a seller, some sellers are quite happy running on their own doing this. Some sellers need a lot of support in it, and I will literally hold their hand throughout the process, help them answer the questions, help them identify the documents, help them organize everything. And then also often we run the data room from our firm as well. So we've got a facility that enables us to collate all those documents, put together a data room and give everyone access to it. So next point is after you've done your DD, it is documents time. And that's really where the main involvement for a lawyer is. So your main transaction document, it's either an APA, an asset purchase agreement, if you're doing an asset deal, or it is an SPA, a share purchase agreement, if you're doing a share deal, so you're buying the whole company. Generally in the UK, we do share deals because the tax benefits are so much greater for the seller. In the US, asset deals are much more common. And it kind of depends on what both parties want as to where you end up. So documents wise, if we're acting for an aggregator, we'll draft those documents. If we're acting for the seller, we will review and negotiate them, or we'll negotiate obviously both sides. But this is the really key document. This contains all the terms in great detail, everything from price, how that's paid, to the warranties, indemnities, the protection the aggregator gets, the protection that the seller gets, the restrictions that are on the seller after completion. So that document is really key. And there's absolutely, I would never advise anybody to embark on that document without legal representation, even if you're a sophisticated aggregator. You need a proper M&A lawyer for it. Once you've done your, or as you're getting towards the end of your APA or SPA process, the next big chunk of process is the disclosure exercise. So a seller, and this is much more important on the seller side, a seller needs to go through all of the warranties very closely with their lawyer and look at whether anything needs to be disclosed against those warranties. So that's where there is something that that qualifies those warranties, or that means those warranties are incorrect, and all that information has to be out there. And that's really important for a seller, because that's the seller's protection against a claim in the future under the warranties. There are often a few other documents on a deal. So you might have an employment agreement or a consultancy agreement if the seller of the brand is staying on for a bit. You might have, I mean, you pretty much always have IP assignment agreements, because the IP is not always in the right place. So you need to get that across. And then once you've got all your documents sorted, you get to completion, and you definitely need a lawyer for this, because you need someone to manage all the signing of the documents and make sure that's done properly, normally done on a platform like DocuSign. And the lawyers will all coordinate that. And then another really important reason for having a lawyer is that you can use solicitors' accounts for transferring the money, so that the seller can be totally sure that that money is there before completion, and during the migration phase, that the money is there and that it will go straight to them once migration is complete. So that really is the kind of main steps in a process from a lawyer's perspective.
Yeah, makes sense, makes sense. And I did hear, and actually we had the same as well, because the SPA is usually written up on the back of the LOI, and that's why you kind of want to brief or use a lawyer already when you do the LOI, right? So there is no kind of inconsistency. Okay, very interesting. And in terms of picking a law firm, right? I mean, there are so many law firms. what are the main, the most important criteria?
I mean, there are hundreds and thousands of law firms out there, and it must be a very daunting experience. I think, first of all, you want to look for a law firm that's got e-commerce experience. There are lots of quirks to doing M&A in this space. There's loads of jargon. And if you don't have a lawyer that understands basic stuff like what is an ASIN, what's a SKU, you're not, before you even get on to TACOs and ACOs and all of that kind of stuff, you need a lawyer who understands the space. I would say that's step number one. Step number two, I think both for an aggregator and for a seller, you will have a much more seamless process, so much less admin for you and probably less cost for you if you instruct a firm that is a full service firm, so that it can deal with all the different elements on your deal, because it's not just a good corporate M&A lawyer that you need a good tax lawyer. You may need a good employment lawyer if you've got employees or if you are thinking of staying on in any capacity afterwards. And you really definitely need a good IP lawyer. So think about finding a firm that can deal with all of that so that you're not having to instruct multiple lawyers all over the place. I'm pleased to say that we at BDB Pitmans are a full service law firm, and we can cover all of those areas for both aggregators or for sellers. Another point to consider is if you're doing a cross-border deal. So for example, if you're a US brand, but you're selling to a UK aggregator, you would ideally find a firm that has a network that they can work with. So again, you're not having to manage two different law firms. You've got one firm that's coordinating the US advice or vice versa. And then finally, I think when you're choosing a lawyer, you want to also look a bit at the kind of soft skills as well. So, get in touch with a few of them, see how quick they are to respond. If they take 3 days to reply to your initial approach, then they're not really going to be speedy enough for your deal. If they don't pay attention to the details that you give them, they don't remember your name or the name of your company, they're not going to do very well on the basic details in the document. And then also, do you get on with them? Because you're going to work really closely with this person over the next few months. So you really do want to feel confident in them and get on with them properly.
Yeah, makes sense. In terms of, it's interesting what you said about the terminology, e-commerce terminology and ACOS, TACOS, etc. Have you actually seen earn-out agreements based on ACOS and TACOS as well? Yeah. Rather than just absolute sales?
Yeah, absolutely. And you need someone who understands that, because if they're blown on that technology, then on that terminology, you're going to have problems.
Interesting. And I guess from your hundreds of deals you did, have you seen any deals where somebody didn't actually have a lawyer at the right time, and what happened? Are there any anecdotes you can kind of disclose?
Yeah, I think what I see more generally, by the time people get to a deal, they have got legal representation of varying qualities, but they have it. What I see more of is people who haven't had legal advice prior to the sale. So there are real big issues in their company that would have been resolved with good legal advice. Something that I've seen several times and has actually killed deals that I've been on is not getting good IP advice. Particularly on an international level. So, I mean, as you know, a lot of brands are manufactured in China, and there's a very, very high incidence and real risk of bad faith registrations for IP in China. This was something that really shocked me when I first came across it. So basically, you have a brand being manufactured in China. They haven't registered any of their IP in China at all. But someone has spotted, just a random third party or maybe another manufacturer that they're not using has spotted this brand on Amazon, has spotted that it's being manufactured in China. And then they go and register that brand in China, which creates all kinds of issues when you try to export your product. Can also create issues with your actual authorized manufacturer. And it can cost a huge amount of money to sort that all out. And that has killed deals that I've been on before. So it's really important that you have an IP lawyer that is alert to these issues, is alert to registering your IP in the jurisdictions in which you think of initially, so the marketplaces in which you're operating, but also more internationally, particularly in China if you're manufacturing your products there.
Yeah, that's an interesting point.
Yeah.
And in terms of warranties and indemnities, I guess on large M&A deals, sometimes people take out a warranty and indemnity insurance. Yeah. Have you actually seen this in the Amazon?
I'm not in this space. No, I think it's too expensive for most people.
Yeah. Yeah. And then I guess, I mean, related to this, let's say, for example, you don't have the insurance, but you still have the warranty and indemnity section in your SPA. Yeah. And then you find out that something is missing or something wasn't passed on to you, and maybe you didn't realize that that was supposed to be in the assets, and then you suddenly realize it should have been there. More often than not, you already spent quite a bit of money, and more often than not, it will take you quite a lot of money to actually enforce these things. I mean, how do people deal with that?
I think you're better off, if you possibly can, thinking about this beforehand. So ways that you can deal with, if you can think about it before you complete the deal, you put some structure in place before you complete the deal, you're in a much better position. So, I mean, point number one, if you've got an earnout, and pretty much all of these deals have earnouts on them, I would always advise an aggregator to have a right of set off for the earnout. So if there's a warranty claim, they can set off the amount of that claim against the earnout, so they don't have to pay the earnout or part of the earnout that represents the value of that claim to the seller. That said, I mean, that's not full protection, because if there's been a big problem with the business, then there's a high probability the earnout won't be payable anyway. So if they're really worried about it, I'd suggest that they have an escrow or a holdback. So they keep a portion of that consideration in an escrow account, and that can't be touched until the period of the commercial warranties has passed. So that's normally somewhere between about a year and 3 years.
Okay. That's interesting. Yeah. Okay, cool. Yeah, very, very helpful. I mean, thank you so much. It was super, super insightful.
That's a pleasure. It's been great speaking to you.